Thank you so much, Keith. And thank you, Mr. Phelps, for sponsoring this lecture and for inviting me to deliver it. And thank you to the Tulane community. I've had a wonderful time. I've never been on the campus before, and I've enjoyed myself enormously. And now I'm about to annoy some people. I begin by urging you to approach my talk by adopting a counterintuitive approach. It's what I refer to as turning into the skid. As I thought about it right as I was about to give the lecture, maybe it wasn't the best metaphor for this climate. You see, up north, they have ice that's not just in glasses. And you learn in driver's ed that when you start to skid, your instinct is to turn away from it. But that is the most disastrous thing you can do. You have to overcome your intuition and turn into the skid, and that's the way to get around it. I have found that First Amendment theory is best understood when one turns into the skid, when one is willing to put aside his or her own particular predilections and approach it behind a Rawlsian veil of ignorance. John Rawls, in his theory of justice, developed this notion of this mythical state of nature where we're determining the rules of society, but everybody's behind a veil of ignorance. You don't know when society starts. Will you be white or black, male or female, smart or not so smart? And his analysis is very similar to that of Clint Eastwood as Dirty Harry. He says, feel lucky, punk. Basically, he assumes people will be risk averse. So you set up the rules not figuring it as a means of strategically advancing your own views, because structurally you don't know what your views are going to be or who's going to be in power when you set up those views. As a result, you have to avoid what I call the level 2 pitfall in First Amendment interpretation. I divide normative analysis into level 1 and level 2. Level 1 normative analysis is an exploration of constitutional theory from a normative perspective, whether it's about the First Amendment or constitutional interpretation, what best achieves the goals of the Constitution in general or the particular provision you're interpreting. Level 2 refers to much narrower ideological, political goals, which are extremely important, worth fighting for, worth battling over, but disastrous if one views them as a driving force to shaping one's own constitutional theory or constitutional interpretation. The Constitution is not the extension of one's own political agenda. And if your intuition is to think corporations are big and evil, let me tell you a story about a colleague of mine, an old and dear friend, Steve Presser, well-known legal historian, an expert on piercing the corporate veil, and the most conservative human being I have ever met. He thinks Louis XIV was a left-wing radical. And in the year 2001, I published a book entitled Money Talks, where I began to compile all my theories promoting the idea of commercial speech and corporate speech. And I autographed a copy and put it in Steve's mailbox. And he sends me an email. You think he'd say, congratulations, thank you, best of luck. One line. It was Redish, : I always knew you were a closet Republican. Now, I was a Democratic precinct captain on the North Shore of Chicago. The only reason I quit is they wouldn't promote me to precinct colonel. But I wanted to teach him a lesson about how the First Amendment works. So I sent him a message back saying, the fact that I defend the free speech rights of commercial advertisers and corporations no more means I'm a Republican than the fact that people defended the free speech rights of communists in the 1950s meant that they were communist. And he wrote back one line. Weren't they? I've never had the guts to ask him, Steve, was that a joke? But it's missing the point of the danger of the level 2 pitfall. To assume that if you are defending the free speech rights of a speaker, you necessarily agree with them. Or if you oppose the free speech rights, it means you necessarily disagree with them. That's not the way we can approach the First Amendment. Now, let's talk about this, the famed and the infamous Citizens United case. What it did and did not hold. What it did not hold was that corporations have a First Amendment right to contribute money to political candidates. That wasn't the issue. What the court held was that even profit-making corporations have the First Amendment right to make expenditures for purposes of direct communication to the public about political candidates and political campaigns. The court did not hold that foreign corporations were protected by the First Amendment. Do you all remember the scene where President Obama is up there at the State of the Union? He's got the Supreme Court sitting there in front of him, and he's chiding them for the Citizens United case. And he says, and you authorized, or he says, the court authorized foreign corporations, and Justice Alito is shaking his head. Justice Alito was right, but what is lost in all this is that was my moment of greatest jealousy of President Obama. Not because he's president, heaven knows, I wouldn't want that, but because he's a former law professor, and a constitutional law professor at that. And the ultimate dream, the fantasy of every constitutional law professor is having the Supreme Court sitting in front of you when they can't talk, and you can tell them everything they did wrong. He happened to be wrong in what he was saying, but that's beside the point. It was such a brilliant moment for a constitutional law professor. The reaction to Citizens United was amazing. Maybe I was naive. I did not expect it. I spoke at a conference at the Brennan Center at NYU about a year after Citizens United on the subject, and there were 18 speakers, almost a who's who of free speech scholarship. And of the 18 speakers, I was one of 2 that thought the decision was correctly decided. The other was Floyd Abrams, who's a well-known First Amendment attorney. So I was the only academic who thought it was rightly decided. But that doesn't even grasp what was going on. The intensity of the hatred of the legal academics for this decision, the comparisons to Dred Scott, and perhaps I should have expected this, because every scholar there was on the political left, and they, I think it's safe to say, were letting their level 2 play out into what should have been purely a level 1 analysis. And in fact, what's so surprising about the reaction is there is nothing new about corporations exercising constitutional rights. Corporations have Sixth Amendment rights to jury trial in criminal cases. They have Seventh Amendment rights to jury trial in civil cases. They invoke the Dormant Commerce Clause. They invoke the Diversity Clause. And they invoke the First Amendment. Media corporations. Do you nothing personal, Mr. Phelps, but do you think media corporations are eleemosynary organizations? Are they not-for-profit? Some would say, descriptively, they are not-for-profit. But they are profit-making corporations. They are big. They are powerful. They are as soulless and as robotic as any major corporation. Yet no one complains about them having First Amendment rights. I watched Rachel Maddow on MSNBC, for whom I have the greatest respect. When she talks about Citizens United, her synapses misfire. And I'm thinking, think of the irony, Rachel, I'm saying to the television. Think of the irony. You are paid millions, I assume, by Comcast, an enormous corporation, So you can say what, at the very least, they don't disagree with, because if they disagreed with it, you wouldn't be saying it. But you don't want any other corporation to be able to say it. Think of the arrogance. Think of the hypocrisy. Well, when I make this point, it's responded to me, but they're protected by freedom of the press. And I say, oh, freedom of the press. And that matters because, and here we're talking about freedom of speech. And what is the difference? Is there some originalist argument that media corporations were supposed to be protected by the freedom of the press? There were no media corporations then. There was Ben Franklin cranking out newspapers. So you have the exact same issue. If you don't like big, soulless, robotic profit maximizers dominating the marketplace, why then do you protect media corporations? In 2003, I think I was the only one who recognized the Iraq War was going to be a disaster. Neither the New York Times nor the Washington Post seemed to grasp that point. Who could I tell my views to? A few people on the North Shore of Chicago and any colleague I could dragoon and couldn't think of an excuse to get away from me. The New York Times, Judith Miller, the question, should she be put in jail? I thought she should have been put in jail just on general principles. Was actually basically a secretary for the Bush administration. Does that mean because they had so much more power than I did, they shouldn't have a First Amendment right? No, I don't think that follows at all. And it doesn't follow for regular corporations either. Now, the Supreme Court has never, ever given the freedom of the press a different or broader construction than it gives to freedom of speech. It has always treated the two fungibly. But if you did want to draw a distinction, what about a magazine published monthly by General Electric? Is that the press? Or are we going to say that the freedom of the press is just one big antitrust violation? It just locks in the media corporations. They've got that special protection, but no other speaker can get that protection. It doesn't make any sense. Now, just to go back to first principles. This point in the semester, when I'm teaching two classes, my voice tends to give out. So. Marco Rubio told me this was okay to do. The three values I put up there is something of an oversimplification, but it's close enough for government work. It'll do. The First Amendment is designed to encourage self-realization. We recognize the individual as an integral unit worthy of respect, worthy of development. Democracy does that, and expression does this. It also performs the function of protecting the listener as well as the speaker. In fact, there are very well-known First Amendment theorists, particularly Alexander Meiklejohn, who thought the only purpose of the First Amendment was to protect the listener's right to receive information. Meiklejohn said, the people we call governors are not really our governors. They're just agents. The real governors are the electorate in a democratic society. They perform their electoral, their governing function when they go into the voting booth. And to make that function be performed most effectively, they need a free and open communication of opinion and information. The First Amendment has also been viewed, Vince Blasi of Columbia being the leading scholar doing this, as primarily performing a checking function. It allows society to check the improprieties of government. Let's examine the idea of corporate speech from those different perspectives. Well, the strongest critique of corporate speech is that the corporation has no soul. The corporation can't self-realize. It is this robotic profit maximizer. What that ignores is why we have corporations in the first place. The history of the modern corporation began primarily in the Jacksonian period. For you younger people, that's not Michael Jackson, it's Andrew. He also wore a glove on one hand. I don't quite understand. The idea was to enable the common person to compete with the landed gentry of Virginia, with the industrialists of New England, and providing them a device to have limited liability was simply a way to help them self-realize. So I have referred to this as catalytic self-realization. If you just look at the corporate form, that's right. It's not a self-realization device. But that's too truncated a view. If you view it as instrumental, think of it this way. There was a football game between Cal and Oregon State a number of years ago, where when the Cal players came out, they decided to pump themselves up. They would take a swing at the Oregon State Beaver mascot, which turned out to be a 5'2" female, who was quoted afterwards as saying, "They don't seem to realize there's a person in here." And it's the same thing with corporations. We think of them as robotic, soulless profit maximizers, but they are devices created by people to facilitate growth and development of people. Now, let me stipulate for purposes of argument that the corporation does not self-realize, and therefore we lose that value of the First Amendment. The First Amendment is not a zero-sum game. It can perform other functions. The corporation provides an enormous amount of information and opinion to voters, to individuals, to recipients of that information. And the First Amendment is fostered by the processing of that information. Who cares what the legal form of the speaker is if the First Amendment value comes from the receipt of information? In New York Times versus Sullivan, the Supreme Court said the First Amendment is supposed to be uninhibited, robust, and wide open in its protection of discussion. I've never thought that the First Amendment is fostered by less communication rather than more. And that's what we're talking about here. The particular corporate speech involved in the Citizens United case was a movie about Hillary Clinton, who's in trouble again, I gather, when she was running for president. It was a very unflattering movie. Why was that not the essence of what the First Amendment is about? Yet according to federal law, for the last 60 days before the primary, this corporation could not make that communication. The key was, what was the communication? Who the communicator is isn't really the point. Finally, and most importantly, is the idea of the corporation as a constitutional check. The framers proceeded on the following premise: in God we trust, all others pay cash. Don't trust anybody. We split the government into 3 branches, not because we liked any of them, because we didn't like any of them, because we didn't trust any of them. And the more checks we can get, the better it is. You don't have to like corporations. You don't have to trust corporations to see how they could be incentivized to perform a valuable instrumental check on government through the bringing of constitutional litigation. And the best way to drive home the point is to just tell you one name: Ernesto Miranda. Ernesto Miranda was a 2-bit hood who was eventually killed in a bar fight in Phoenix. He's got his name on one of the most famous constitutional doctrines there is, Miranda rights. Ernesto Miranda was incentivized to raise those issues about the right to have the government not trick a defendant out of his or her constitutional rights, because he would benefit from the process. You don't have to like Ernesto Miranda to believe that he was appropriately given the instrumental constitutional check that the corporation performs in the First Amendment as well. Think about the following law. Congress passes a statute that says corporations are allowed to use their Treasury funds to criticize the President of the United States. No corporation, however, is allowed to use its Treasury funds to defend the President of the United States. Normally, my hypo, I have that reversed, but with this Congress, I set it up this way. Who could imagine a more outrageous form of governmental viewpoint regulation? But if corporations don't have First Amendment rights, they can't challenge that. Yet that law would continue. This introduces what I call the regulatory-centric model of the First Amendment. There are basically three non-mutually exclusive models of the First Amendment. There's the speaker-centric model, the listener-centric model, and the regulatory-centric model. The speaker-centric model is we want to protect the speaker and help the speaker develop, and that's why we protect his or her speech. The listener-centric model is Meiklejohn's theory that we gain in the democratic system by receiving information. But the regulatory-centric model is different. The regulatory-centric model posits that even when we don't really care much about the speaker or the listener, there are certain ways in a democratic society we don't want government to behave. There is basically a violation of the liberal constitutional social contract when government treats its citizens in a certain way. And corporations are incentivized to bring those challenges. When government, for example, and I dealt with a lot of these, government agency regulations, FDA, FTC, SEC, they're often based on a paternalistic model that is pathological to democratic society. They are often based on the premise that we should restrict communication that is truthful, advocating lawful activity, because we cannot trust the public to make the right choice. But you cannot cabin that kind of paternalism. If we can't trust them to make certain purchasing choices on the basis of free and open debate, how do we trust them to decide whether we want to get into another Middle East war? Either people are sheep or they're not. And if they are not sheep, then it is unconstitutional. It is constitutionally pathological for government to suppress truthful speech advocating lawful activity on the grounds that people can't process the information properly. Well, who's got the incentive to make those challenges? The drug companies, the advertising companies. In this way, corporations are the leader of the regulatory-centric model, and they can perform checking functions that supplement the checking functions performed by the media corporations, which at various points they have been spotty. Now, when you talk about corporate free speech rights, it inescapably spills over into other related but not identical subjects. So I wanted, having hopefully laid the foundation for why the Citizens United decision was absolutely correct, I want to get into some issues that are in the background that are bothering people when they talk about Citizens United and criticize it, what I call satellite issues. Satellite issue number one, money and the political process. This is not unique to corporations. Sheldon Adelson, the Koch brothers, and there are billionaires on the liberal side as well, who have enormous amounts of money, who can dominate the process. And restrictions on corporate speech rights go hand in hand with efforts to reduce First Amendment protection for the use of money. And the argument I often hear by proponents of these laws, by my friends in Common Cause and people of that viewpoint, is that money isn't speech. We're not regulating speech. We're regulating money. So the First Amendment isn't involved. Think of the irony. The reason they want to regulate the money is that it buys too much speech. But think about the following law. The New York Times is or all newspapers are prohibited not from publishing. They're allowed to publish. They're prohibited from buying newsprint, from paying their workers, or from buying equipment. But we haven't affected your freedom to publish. We've just affected money. Even poster board and markers cost money. So to say you are regulating money, not speech, is either preposterously naive or just more likely disingenuous. That doesn't mean you shouldn't regulate it. But don't tell me you're not regulating speech when you're regulating the money. The way people communicate in a large democratic society is by taking out ads, by spending money. And ads provide information. Sometimes they help the candidate, sometimes they don't. But think of the 2012 Republican primaries, where Newt Gingrich has a tremendous victory in South Carolina because, I'm assuming, Republicans of South Carolina had amazing amnesia on the day of the election. Mitt Romney's PAC in Florida decides to remind the Florida voters of Newt Gingrich's past. And I saw, again, I watched too much MSNBC, but I was watching the commentators on election night saying the Romney campaign just bought this primary. And the one Republican they had on there said, nothing they said was false. Everything they said was true. And it was money that communicated the information to the voters who then acted on it. Mission accomplished. That's democracy. I've heard there are respected constitutional scholars, Rick Pildes at NYU and a number of others, who have come up with the idea of the speciality of electoral speech. That elections are so important that they're beyond the First Amendment. And I think the irony in this, the very first article I ever wrote was my third-year paper at Harvard Law School, arguing as a matter of First Amendment theory that commercial advertising deserved First Amendment protection. At the time, no one had ever suggested commercial advertising deserved protection. At Harvard, people keyed my car. They pushed me into the lockers. That was just the professors. It was published in the George Washington Law Review, and as a result of, well, I'd like to think as a result of that, but we could argue that commercial speech became recognized as having value. It shows that money and the incentivization of making more money is actually fully consistent with what the First Amendment is all about. The second satellite issue is related to the first. the idea of equality in the First Amendment. The reason we want to restrict money, they say, is because a lot of people don't have it. And that creates inequality between speakers or candidates. Well, one way to achieve equality would be to pass a law saying no one can say anything about anything ever. Totally equal, but not consistent with the First Amendment, I think. An equality of ignorance is not what the First Amendment is designed to achieve. There is more at stake than simply equality. And sometimes that's going to mean some people have advantages, others don't. Money is not the only one. When Ronald Reagan ran for president, or actually for governor of California, do you think it was just money that got people to know him? When Arnold Schwarzenegger ran for governor, when John Glenn ran for senator, they have built-in reputations, and it's often money that's the only thing that can equalize it out. The 1971 Campaign Finance Act was jokingly referred to in the halls of Congress as the Incumbents Preservation Act. Incumbents have a franking privilege. Incumbents have access to the news. Incumbents have offices in their communities. The only way to beat them, many times, is with money. But somehow we've decided the only thing we're going to bring about equality in is money. And all we're doing is reducing communication, not increasing anybody's communication. And even if you aren't persuaded by any of these arguments, in Federalist 10, Madison, as he was writing about factions, and expressed so much fear of factions, said we could try to control factions by simply suppressing their liberty. But, he added, the cure would be worse than the disease. And that is so often true in the case of the First Amendment. Do you think people who believed in the First Amendment liked the idea that Nazis in 1977 were going to march down the main street of Skokie, Illinois? No. But at times, the cure is worse than the disease. And a drive towards equality can only have a dampening effect on the amount of information communicated. And finally, the satellite issue number 3. Young scholars like Zephyr Teachout have been raising recently, the First Amendment and the public interest. The problem with corporate speech, the problem with evil speech, is that it is self-motivated. It is self-interested. It is not looking out for the community, for the public interest as a whole. Well, this is sort of the theme of my last book, The Adversary First Amendment. The First Amendment is about allowing people to advance their own interests through communication. When welfare recipients picket for an increase in their benefits, they are promoting their self-interest. When African Americans in the South sat in at lunch counters in the 1960s, they were promoting their self-interest. When any candidate for office speaks, he or she is promoting their self-interest. And that's accepted in every other area of the First Amendment. In no area of the First Amendment, other than commercial and corporate speech, is a speaker denied protection or given reduced protection because he or she is speaking out of self-interest. We are all adversary in one way or another. And like in the adversary system, we can discount the persuasiveness of speech because of the self-interest of the speaker. But it doesn't mean what the speaker is saying is not very valuable and very helpful. Thank you very much. I am more than happy to take questions. Yes.
How do you respond, or perhaps more accurately, do you even care about the view of your colleagues or counterparts at University in South Chicago who say that the sole and only business of a corporation is to maximize shareholder profit? They have no business whatsoever addressing social issues.
Well, those two, the second statement doesn't necessarily follow from the first. I do agree with the first.
I agree. They can be, social issues can certainly advance the benefits to the shareholders, but many times it doesn't. Let's talk about the times that it doesn't.
Oh, that it doesn't? Well, I have no problem with the neutral application of corporate law. If it's not discriminating against speech, if there's a general rule saying corporations, I assume publicly held corporations, have an obligation to the shareholders to maximize profits, and that it is ultra-virus to spend money on something that won't ultimately lead to maximization of profits, I would say that could be applied to speech as it is to other things. But corporations, particularly in political campaigns, will comment on social issues because they've got an agenda there. And usually, frankly, the corporations I know, the people who work at the corporations I know, might on their own get involved in social issues. I've not seen corporations get involved without in some way benefiting them. A lot of corporations in Chicago contributed heavily to the building of Millennium Park, which is this glorious park that they built in Chicago. But that was done to make Chicago a more attractive place, to attract higher level people to work at Chicago corporations. So I have no problem with the application of that rule, but in the cases where they're consistent with corporate law and they are promoting their own interests, I see no problem with giving them First Amendment protection. So I think I can live with that statement. Yeah.
I actually kind of want to piggyback off that because I think one of the stronger arguments is to say, so we have the corporate form as an aggregation of interests and power, right? But it's there for a purpose, profit maximization. And it's not just that maybe Shell's promotion of a tax, Shell Corporation's promotion of a certain tax agenda may benefit Shell and therefore me as a shareholder, but it may also be something I personally dislike. And so in a sense where like, I'm subsidizing a kind of speech I dislike. And the counter to that is, well, Shell should just have a PAC. And I don't necessarily have to be aggregating my power in the PAC. But this is sort of exactly what Citizens United said Shell didn't
have to do. Yeah. Well, let me ask you a question in response. If Shell wants to make an investment that you don't agree with, do you have a veto power on their investment?
No, but that's part of Shell's mission statement, to make investment.
Well, now we're begging the question. I mean, if Shell says publishing this communication helps Shell's interests, you may agree or disagree with that, but fight it out on that ground. Don't fight it out on, yes, it may help Shell's interests, but I disagree with it. If you disagree with it, sell your shares. In no other area of corporate choice does a shareholder who disagrees with a choice have a veto power. Why should they have it when it comes to communication by the corporation? I would treat it the way we treat all corporate decisions. Shareholders don't like it. They can get into a proxy fight, whatever, or they can sell their shares, or they can live with it. But I don't see why there's something unique about speech by corporations that should give shareholders more power than they have in any other decision they make. But, yeah.
What if the Russian government or the Chinese government, or to use a topical example, the Israeli government, were to want to flood money into an election campaign to advance a particular political agenda? Would you say that they would have a First Amendment right to do so? I guess that the end of my question. But if they don't, why should it be any different for a corporation that has chosen to maintain corporate personality in the United States, but to offshore its structure so that it pays no taxes in the United States, it doesn't have to have it doesn't have to bear the political consequences or the citizenship consequences?
Yeah, I think it's a close case, but I think we could say national security considerations categorically allow the exclusion of money from foreign corporations. As I say, I can see an argument the other way as well, but it wouldn't upset me a lot if they came out that way. As for the kind of corporate tax shelters you're talking about, if I understood that, I wouldn't probably be doing this. So I really can't speak to the details of it, but I would follow the model of saying, are they in effect a foreign corporation? If they are, then I would treat them as however we've decided we're going to treat foreign corporations. Do corporations really do that sort of thing? It's very disillusioning. Any other? Yes, Keith.
As you know, I agree with you that corporations do and should have a First Amendment right of free speech, but I think where we may differ is whether or not the level of protection that they get should be equal to those as individuals receive. And so I'm wondering about the analogy. You make the analogy a number of times in your talk between commercial speech, commercial advertising, and the political advocacy in Citizens United. And of course, the court did decide to protect commercial speech, commercial advertising, but it didn't give it full protection. It didn't give it full protection precisely for the reasons that some of the arguments, that there's something about the quality of commercial advertising that merits some First Amendment protection, but there's something also about the quality of commercial advertising that should subject it to legitimate regulation. So if I can advocate for illegal activity, but I can't advertise for something that's illegal. I can engage in, I can speak falsely in a political statement, but not in a commercial advertising. So in that area of corporate speech, there's some but not full protection, and there's areas for government regulation with respect to that speech that's not available in other settings. When you're discussing the fit between the Citizens United claim for First Amendment protection and how it fits for First Amendment values, it's interesting to me that the corporations kind of clearly get 2 out of 3. And I agree with you on the 2 out of 3, that it enhances information, it can provide a check on the government. What they don't get, the value that they don't get is self-realization. And so there again, you have, in this setting, the corporation, aligning with some values of the First Amendment, but not all of them. So,
and the media corporations don't have the self-realization.
Well, no. So, no. I don't think that. Sorry, Ashton. I don't think media corporations self-actualize either. I think it's not that I'm aware of. So explain to me why. In this area, there shouldn't at least be thought, and as you know, I don't have a precise line, a precise doctrine of what it would be, but intuitionally, it's always seemed to me like some sort of middling position for corporate speech in the political sphere also makes sense. That there's something about business corporations that could legitimately subject them to speech regulations that would obtain for corporations and not for individuals. So just speak to why the middle course isn't available here, but it seems to work perfectly fine in commercial advertising.
I happen to have another set of PowerPoints on commercial advertising in the First Amendment. If you'd like to take another hour, I could.
I'd say absolutely.
Yeah, you struck some chords on that one. First of all the limits on commercial speech protection that you mentioned are there, but even given that, it's not your father's commercial speech protection anymore. I mean, at least for truthful speech for a lawful activity, commercial speech protection is virtually fungible today doctrinally with regular speech. The government has not won a commercial speech case in the Supreme Court since 1993. Only the Chicago Cubs have a greater history of failure than that. But having said that, I never understood the distinction of commercial speech. Consumer Reports gets full First Amendment protection. When Ralph Nader criticizes the Chevy Corvair as dangerous, and I don't believe that, I'm going to buy one soon, he's got a full First Amendment right to say that. When GM defends itself and says, no, we're not, all of a sudden they don't. I mean, what an outrageous discrimination on the basis of corporate values. The thing about commercial speech, it has no rabbi. The conservatives don't believe much in the First Amendment, and the liberals don't like commercial advertising. So it sort of falls between two chairs. But if you're going to give full First Amendment protection to Consumer Reports and to Ralph Nader, I don't see what the difference is for First Amendment purposes between them and the commercial advertiser. But as to, in the political realm, doctrinally, Citizens United was not that much of an outlier in earlier decisions involving Massachusetts. The Supreme Court said corporations have the full panoply of First Amendment rights. It's the Bellotti case, the full panoply of First Amendment rights to speak about political issues. It was the Austin versus Michigan Chamber of Commerce case that was the aberration, the case that Citizens United rejected. So I guess I don't see the logic behind it. I mean, you said there's something about the corporation. I would chalk just those words, up to the kind of intuitive stuff and you need to turn into the skid that, there's just something about corporations. Well, if we followed our intuition, well, the Nazis wouldn't be marching either, and in some ways that might be a good thing, but not for the First Amendment. So I just don't understand the logic of giving them less protection. If you give them less protection, I don't see why media corporations get as much as they do. And if you did have a logic, now that I remember it, it was it was 2 of 3 instead of 3 of 3. I don't see why satisfying any one of those fully fosters First Amendment values. If somebody puts something in his or her diary to be communicated to nobody else, that should get full First Amendment protection because it's part of the self-realization process. It doesn't advance information or to the electorate. It doesn't serve as a check. Most art and theater doesn't serve as a check on government, yet we still give it First Amendment protection because it checks the first box. Checking any one of the 3 boxes should be enough to trigger full First Amendment protection. It's not a zero-sum game. We don't have a limited pie of First Amendment protection. Oh, you give it to him, we won't have more to give you. It can extend like the internet, which I gather is very large. And it'll be at least years before it's filled up all that space. So, yeah.
So I agree with you that the First Amendment...
You couldn't just stop there? Sorry.
I could, but it wouldn't be the truth.
Uh-oh.
That includes a right to speak and a right to hear, to listen. But if 1 or 2 people have the huge, powerful speakerphones, microphones, and everyone else is relying on their voice, then you're only hearing one or two people. And I also thought, from when I studied con law, right before I took the bar, that there was a marketplace of ideas, not just a bully pulpit for one or two. So if you're going to give free speech to the corporation, then don't you have some kind of process or regulation that keeps it accessible, really, as opposed to theoretically, to people who don't have the money, that don't have the big money?
Well, and that's an interesting idea. They've tried to work that out with funding campaigns. The problem with funding campaigns is that you have to conditionally sign off on not spending anything more than the amount given. If there were publicly funded elections, President Obama would not be president. He raised so much money off the internet, he far exceeded the limits. If he didn't have a choice about those limits, if he had to take it, nobody would ever found out about Barack Obama. The key. Not if you like Barack Obama, it's not. I mean,
taking shots at publicly funded. In your scheme of letting everyone have free speech rights, how is there a way to protect, not just public funding, and maybe giving, I don't know if I believe this, but maybe giving it to newspapers is more to newspapers than to other corporations, is part of what the First Amendment, in its originalist belief, which I don't believe in, really meant. That we want the press to have this right because we believe the press is the best way to let everybody hear.
Well, first of all, nobody has a clue what the originalist understanding of the First Amendment was. Madison wrote the Bill of Rights one Sunday afternoon watching the Patriots game, drinking a bottle of Sam Adams, and they just went through very quickly the state ratifying conventions. Nobody really understands what the assumptions about the First Amendment were historically, but I guess I don't see the logic. Why do we want to trust the press? Has the press... Nothing personal, Mr. Phelps. Has the press justified that kind of investment of power? Why should we trust them without having a check on the press? Who's going to check the checkers? And having dealt with the press in numerous instances, their record has been fairly spotty on how accurate they are, how well-intentioned they are, which is not to suggest they shouldn't have First Amendment rights. But again, it's don't trust anybody. Let everybody speak because we don't trust anybody. Now, in terms of the dominance you're talking about, the Internet actually is something of a safety valve there. It's not a full answer. But people communicate by the Internet and get information by the Internet, and that doesn't cost anything. And there are a lot of stories that the press has sat on that have come out through Internet stories. Is that the press? Or is the Drudge Report the press? I mean, I don't want to start getting into that kind of definition. I find that troubling. And it comes back to, ultimately, sometimes the cure is worse than the disease. Yeah.
I have an issue with the consequences of elections. Corporations do not breathe, so they might not be interested in clean air. They do not drink, as you are now, because they might not be interested in clean water. They probably do not need social security or health care. And corporations won't be the boots on the ground if there's a war. So I'm worried about the influence of someone or something on an election that obviously has consequences. Let me add one little element to that. As a German that has lived more than 10 years out of his country, I've lost my federal election rights because I'm too disconnected from my people. If I were to vote right from here in Germany, I would be affecting an election that has very little to do with me. Whatever the legislature in the next 4 years does wouldn't have much of an impact on me. Now, there are pockets where that's not true, but on balance, the consequences of a federal election on a German, that's the theory, who's lived out of the country for more than a decade, are too small to justify his right to vote. Corporations are different. They're not equal to human beings. The consequences for them, though they do exist, are, I think, in some fundamental way different from the consequences on human beings. How does that work out in your theory?
I guess I'd have to disagree. Corporations are enormously affected. The people who work for corporations are enormously affected by elections. If the government,
right to vote.
I'm sorry?
They have a right to vote. They can vote.
Well, just because you don't have a right to vote doesn't mean you don't have a right to speak. But GM was significantly affected by whether the government was going to bail out GM or not. The whole corporate world was affected by what we do or don't do about the recession. And the people that work for the corporations are, and the people who own stock in the corporations are all affected. You may not like the way the corporations come out on things. They may be against clean water because it's going to put a burden on them. But that's where we can't shape our First Amendment law based on whether we like the results that would come from the speaker. The New York Times doesn't vote either, yet they have First Amendment rights.
And I'll qualify that by saying German constitutional theory will draw a distinction between freedom of the press and freedom of expression in general, which is something which is different in this country. So there's a different philosophy.
Oh, there are a lot of different philosophies. In Germany, I gather, it's a crime to say the Holocaust never happened. I don't think that would ever get by under our First Amendment. And maybe that's perfectly appropriate that we have different histories, and maybe that's perfectly appropriate. But all I'm suggesting is that a comparison to Germany or to any other country is not perfect.
What I'm suggesting, I'm just thinking of the consequences of.
Well, but what's troubling,
but you whatever it is.
That's level two. I mean, to say we're going to not protect speakers because those speakers might influence election of candidates who will do bad things is just not a way you can function. You're not behind the veil of ignorance anymore. It's simply anathema to basic First Amendment precepts, for good or ill. Yeah.
You get back to the veil of ignorance. I don't see, given my limited understanding of Rawls and his theory, that if you don't know where you're going to fit in the hierarchy, you'll want some equality of opportunity, maybe, or even outcome. And then, after you mentioned that, you pushed aside equality as a reason for the First Amendment, equality of money and what have you. And how do you get from a veil of ignorance to the situation that you are proselytizing for?
Okay. When I
25 words or less.
No, it's an excellent question. Usually I can skate by on this if I don't get called on it, but you called me on it. When I invoke Rawls, I'm invoking an analogy to Rawls. Heaven knows Rawls's ultimate difference principle would not produce the result I'm suggesting. I'm saying similar, and frankly, I think there are tons of problems with Rawls. So I'm not advocating his theory. I'm picking up one structural device that he used, the idea of determining rules before we know who they're going to help and who they're going to hurt. And I'm not suggesting a view of social justice on the basis of it. I'm suggesting that has to be the way we view the First Amendment, lest we set up a system of viewpoint regulation. You can't have the Supreme Court saying picketing by socialists is unconstitutional, but picketing by the Chamber of Commerce is constitutionally protected. I mean, you can't. you have to set it up saying picketing is either protected or it isn't, regardless of the views being expressed, or you set up a Hobbesian, forget Rawls, a Hobbesian state of nature where life is nasty, brutish, and short, and the First Amendment couldn't function. So you're right. I'm not drawing a full analogy to Rawls. I'm just surgically slicing out one device that I thought was very helpful, and you called me on it. So, thanks a lot. Any other questions?
We have a reception set up in the multipurpose room. You can continue the conversation there. But please join me in thanking Margaret.